Good afternoon, everybody. Aaron Keller here at the Law and Crime Network. Great to be with you a little bit earlier than usual today as we continue to monitor the situation in the Tex McIver murder case out of Atlanta, Georgia. The jurors just notified the judge that they wanted to have lunch, so they're headed out. No verdict anytime soon. It's lunchtime as jurors continue to pore over days upon days upon days of evidence that was presented slowly, sometimes disjunctively, but certainly surely, as prosecutors tried to push towards a verdict in this case. Again, it's the case of an attorney who's facing murder charges. We have an update to sort of wrap together what happened during closing arguments. Rachel Stockman has that for us now.
Jurors are deliberating whether Tex McIver is guilty of murder, aggravated assault, weapons possession, and influencing witnesses. McIver says he accidentally shot his CEO wife, Diane McIver, when a friend was driving them home from dinner after a day out at their ranch.
In this case, we know by way of the evidence that this is not an accident. This is not a malfunctioning gun that just went off.
The defense challenged that by reminding jurors of a huge piece of testimony.
Oops. He's demonstrating it for you on the witness stand. He accidentally pulls the trigger.
The state says the trajectory of the wound, just inches from the victim's heart, was deliberate. The defense says the state's theory relies on too many coincidences.
Diane tells the doctors and the nurses it was an accident. Is that part of the plot? Is that something that the state's going to claim, that Tex McIver had this thing so well planned and calculated, he convinced the last words that his wife said was, it was an accident? I mean, we're not talking about reasonable doubts here. We're talking about just astonishing improbabilities.
Friend Danny Jo Carter was driving the McIvers home the night of the shooting. The highway was clogged, so she took the surface roads through a neighborhood Tex McIver considered unsafe. He asked for his gun. His wife handed it to him.
If you're going to murder someone, why do you shoot her in front of her best friend? Why would you do that? Come up with one reason that says, I know what I'm going to do. I'm going to wait till Danny Jo Carter is, 8 inches away from me and 8 inches away from her best friend. That's when I'm going to commit the crime. And try to sell that on, to Hollywood or a TV show, and they say that's a ridiculous plot. It makes no sense.
Prosecutors pointed to a financial motive.
In this case, we know that the defendant was under pretty extreme financial stress, that he was living up here and earning down here.
And y'all have seen hundreds of thousands of dollars flow into that estate account and flow out. They still haven't been paid. Why? He never intended to pay them. This ain't no Chef Tex, Southern gentleman. He's a guilty murderer.
The defense disagreed.
These are their witnesses that they want you to credit. Every one of them talked about how much in love they were. Every one of them testified that there was no arguing between them, there was no hostility between them, there was no animosity between them, and yet the jury wants you to, the prosecution wants you to just ignore all that and say, nevertheless, 10 o'clock, Sunday night, September 25th, I'm going to kill her, the woman I love.
The case has been filled with strange insinuations, like that the defendant was having an illicit relationship with a masseuse. On the stand, she denied it. Prosecutors tried to walk back that theory.
Never said they had sex. This is what I am saying. It just don't look right. I don't care how you cut it, Mr. Defendant. It just don't look right. And it is not consistent with the person that you have portrayed yourself to be.
Jurors have a lot to sort out in deciding McIver's fate. This is Rachel Stockman for Law and Crime.
Okay, everybody, that was a recap of what had happened throughout the closing arguments in this case on both sides. I want to bring Andell Brown into the discussion. He's an attorney, and he joins us here regularly here on the Law and Crime Network. Andell, good to see you today.
Great seeing you, Aaron.
Okay, so what do you make of this? We've got the defense saying that this plot that the prosecution is trying to sell is so ridiculous that nobody in Hollywood would bank money on a script that suggests that a guy would murder his wife 8 inches away from her best friend and an acquaintance of the two of them. Is that an argument that you think could win the day?
I think when I look at this case, Aaron, the issue that I see is that the prosecution is asking all of these questions that they want the defense to answer when the burden is on them. Their theory of the case relies on a whole lot of what ifs, what about this, what about that. They're not getting to the point of why Tex McIver should be guilty of murder.
They've got these issues about, is there another will? Okay, as you said, that kind of points it back to the defense. They're wondering, is there a financial issue? Is there a financial motive? I think the defense has been able to at least raise, at a minimum, reasonable doubt, but at a maximum, a better picture of the defendant's own finances than the state was able to raise. So, if the state's got all this power and this money, where are the forensic accountants that can drill this down and make it more certain?
Well, unfortunately, as you pointed out, unfortunately for the state, Aaron, their case seems to have been laid out kind of in various disjointed directions through the course of this trial. I mean, we've seen this trial going on for in excess of 20 days, and it seems like the state is hoping that the jurors will latch onto this or latch onto that instead of sticking with the central theme and hammering it home. I think there is something there that the state has to work with, but I think they've gone all over the place chasing different theories that they haven't got the jurors to focus in on that fact. This looks like it was the perfect crime in a sense of you commit the crime, you solve the problem that Tex had, which was control over the finances in their marriage and what was going on between him and Diane, and you have deniability to say that this was an accident. If everything is as it was, without Tex speaking, without him making those statements, without him talking to witnesses and allegedly trying to get them to change their testimony, this would be an easy not guilty. However, he did do those things. He did get involved with those people. The problem is the prosecution isn't focusing on their best facts. I think their best facts are that Tex was a gun expert. He knew how guns work. He knew a lot about them. And for him to accidentally shoot his wife just doesn't make a lot of sense. The defense comes back and says, look, if someone was going to shoot their wife and plotted to kill her in some grand mastermind scheme, why would they shoot through the back of a seat which has all these parts and mechanicals and other things that can divert the bullet? One of the things that struck me in the case was that the bullet that was used was a full metal jacket. Those are the types of bullets that were in that gun versus hollow points or another type of bullet. The difference between the full metal jackets and the hollow points is hollow points, when they hit something, they spread. The full metal jackets, they're not used by police departments anymore because they had problems of them going through the intended target and going through several other things. So we know that anyone who's a gun expert would know that those types of bullets are the types that will penetrate several layers and go through almost anything you shoot it at.
These are great points, Andell Brown. I want to continue this conversation, but look, I want to update people on what's going on in the courtroom right now, and the answer is the jurors have said, we're hungry. It's time for lunch, so we won't have a verdict anytime soon. We continue to monitor that situation. While we monitor that courtroom, we're going to break down the prosecution rebuttal, okay? We call it a rebuttal, but in many cases it becomes the ultimate closing argument. It's the last word. The prosecution has the burden. The prosecution gets the last word. Clint Rucker was the lead prosecutor in this case. He's the one that gave the rebuttal. Let's break this down bit by bit, starting from the very beginning. Okay, folks, we're going to break in at this point. That's Clint Rucker. He's the lead prosecutor in the Tex McIver murder case out of Atlanta, Georgia. To help us continue to break down that rebuttal argument, we have Andell Brown from Miami. We also have Charles Mittelstadt, who's in Atlanta. Charles, you know these guys. The shaking up the glass of water, we were just saying, is for those of us in law, is kind of a tired euphemism. It's been done, but you say Clint Rucker uses this all the time.
I think he's got the patent on it. Every single high-profile case that I have ever seen a man have ever been on the other side of. He has deployed his muddy water clothes. It's, in fact, I was telling you off air a moment ago, I even hid it from him once during a recess just to toy with him. But I bet some colleagues yesterday that 10-1 that he was gonna deploy the muddy waters clothes. And again, here it is. In this case, though, it really applies to the prosecution's approach to this case. They threw a lot against the wall to see what would stick, and now it's time for the jury to try to sort it out.
Okay, let's talk about another legal issue here. The beginning of this rebuttal was all about the victim. And look, the Supreme Court has sort of been back and forth over the course of the Supreme Court's jurisprudence as to how much emphasis the prosecution can put on the victim. I think that here it was pretty safe, though. The prosecution referenced the victim, didn't go into an extreme amount of detail about how we should feel sorry for her and she was taken too soon. There was a little bit of emotion there, but it wasn't too much. Andell, what do you think?
Well, a long time ago, I had one of the older trial lawyers tell me, when the facts are on your side, you pound the facts. When the law is on your side, you pound the law. When neither's on your side, you pound the table. It looked like he was taking them to church about Diane McIver. He told them who's going to fight for her. Lovely poem, great oratory. Very little facts, very little evidence, and I think that is just a summary of the prosecution's case here. They have a lot going on, but when it comes down to the meat and potatoes of the case, there's very little there.
Yeah, Charles, look, I mean, I'm sitting here watching this. I don't know these guys. You do. I would give Clint Rucker, the senior prosecutor there, an A+ on theatrics. He's got a great command of space. He's got a great command of voice. He has a great command of presenting stuff. I probably would give him a C- on logic, though. In this case, do you agree with me?
100%. I mean, that is both opening and closing argument are Clint Rucker's strengths. It's his forte. He does have a very significant presence. I've been in cases before where we've talked to the jurors after. They all love him. They like his style for the most part. He is a force to be reckoned with. He is District Attorney Paul Howard's show horse in that office, and come game day, he can bring it, and this is his strength. But as Andell pointed out very aptly, where's the beef? It's all show and no go, and that was essentially the trial. Really, they just never delivered. There was all these undelivered promises, as the defense said in their closing, a lot of red herrings along the way, and so. He's worked with what he had to work with, and that's what he's great at, turning something out of nothing. But at the end of the day, I think we've surmised by now from the jury's questions, and this is an unusual circumstance where you have a judge that has allowed the jury to ask questions of almost every witness. And so, but through that process, we've learned that these jurors have been very, very engaged. They've been alert and engaged even at times when the testimony, frankly, was extremely boring. And so I think they're very diligent, and I have confidence that they're going to sort through his closing argument, and they're going to be looking for the things that ultimately are argument versus the evidence that they heard with their own eyes and saw with their, or heard with their own ears and saw with their own eyes.
Exactly. Look, I think that the prosecution did, despite our concerns with the overall case, make some great points. I think that this guy is probably guilty of something. I don't think it's a top charge here. Let's pick up where we left off and continue taking a look at these closing arguments on the rebuttal. Welcome back, everybody. We continue to break down the Tex McIver murder case out of Atlanta, Georgia. The jurors have the case. They're deliberating, at least after lunch, after they come back today. Charles Mittelstadt, Andell Brown remain with me here. Look, this is one of these areas of this prosecution where I think the prosecutors make some great points. They've got these emails that indicate that there's a disagreement about how to move forward with a will. Great point. The problem is the emails are from 2011, and Diane McIver didn't die until 5 years later. Andell, is there just too long of a gap there for the state to logically argue that there was a lot of animosity about how these two were going to settle their estate someday?
Absolutely. There's just too much time that passed between that those emails in 2011 and the ultimate event that we're talking about. There's a lot of other conversations, there's other wills and other things that came up that the state has not been able to tell us exactly how that ties into their theory of the case. So I think the problem is that they began this case by telling the jury that they don't have to prove motive, they don't have to prove intent, and then they spend half of their closing talking about motive and intent.
Exactly. Now, Charles, you have a theory about how this case was moving forward that we were discussing. These are some pretty tough charges. This is the top charge. This is murder. They're not going for a lesser charge. It was eventually added in, but the prosecutor really went at this thing full throttle, even though that murder charge has been tough to prove. What's your theory on why they reached that far up the chain of possible charges here?
Well, there's several possible theories, but if you recall, the case originally was charged as a reckless conduct, involuntary manslaughter case. We heard from Detective Smith with the Atlanta Police Department. That's how we saw the case. The district attorney's office essentially overruled the Atlanta Police Department's judgment and decided to pursue this as a murder case. I think, in fairness, probably some of Tex McIver's own conduct has contributed to that. He has been his own worst enemy from beginning to end in this case. Had he not engaged in certain actions that, in my opinion, don't necessarily prove that this was premeditated. It just proves that you have somebody who's flawed, who's an attorney, who's overthinking, who's trying to shape narrative, control spin. But he absolutely did some things that were ill-advised, exercised some very poor judgment. One of those things was involving these media consultants, Jeff Dickerson being the second one of them. And he essentially engaged Dickerson because of the relationship that Dickerson had with Paul Howard. They were friends, our friends, have been friends for decades, and essentially he was trying to buy some form of, best I can tell, buy some form of access to Howard. The state is alleging, of course, that was for purposes of bribing him to make the case go away. The evidence simply didn't bear that out. And let's also remember that McIver isn't even charged with that. If they felt that strongly that he had attempted to do that, he would have been charged, and he wasn't. But it's clear that he thought that if he could get somebody to advocate on his behalf, that potentially this could all go away or be minimized. He did so, I think, perhaps imprudently by dispatching Dickerson to make that reach out to Paul Howard directly as opposed to through his attorneys. Naturally, it's an unusual thing. Generally, that's your attorney's responsibility, your job to go and meet with the prosecutor, with the district attorney to try to talk to them about the case, see where they want to go with it, see if they can't perhaps reduce the charges, come to some plea agreement. But in this case, Dickerson did that independently. And I think it put Paul Howard in a very awkward position where he may have had some concerns about the optics of that and the propriety of that. And that may or may not have contributed to the way this case got charged.
It's another one of these bizarre occurrences. Andell, we're going to pick up with our review of this. What arguments did the prosecutor need to make here that you think the prosecutor didn't make?
Well, I wouldn't say it's so much that he didn't make those arguments, Aaron. I felt like those arguments were made in passing. I felt like they were made supplementary to this greater idea of talking about why Tex McIver had a reason to do this. We understand that there was a reason possibly for Tex McIver to do that, but I didn't feel like the prosecution spent enough time focusing their argument, focusing the capital they have of the jury's attention on their best points. I think their best points were the facts that Tex McIver is a gun expert, someone who deals with guns on a regular basis, does not take lightly the fact that you don't put your finger on the trigger of a gun you don't intend to fire. They don't take lightly the fact that you don't point a gun in a direction where you don't want to take out a target, either to kill or injure someone. I think those are things that everyone who handles firearms knows. And for someone like Tex McIver, who was alleged to have been able to shoot a water bottle out of the air and had several gun exhibitions and taught people about guns on his ranch, I think it's just ludicrous to go with this idea that the defense has presented that, oops, I just pulled a trigger that with several pounds of pressure and shot my wife accidentally in the back. And then I think they touched on it about the fact of him falling asleep, that he was in a very high state of alert, that there were literally 3 minutes between the time where he said, give me the gun, and the time he allegedly fell asleep and shot Diane McIver. I think those all fly in the face of reason. But when it boils down to it, the evidence shows, in my opinion, that Tex McIver may have had some reasons to want Diane McIver dead. He may have had some contentions in their relationship that revolve around money. He more than likely was not truthful with the police. He more than likely did not fully disclose his information. He changed the story a couple times. He tried to influence witnesses and other things like that. I think all of those things were established by the prosecution. But the one important fact I don't think was established or can be established in this case is that it was not an accident. He may have been careless and caused Diane McIver's death, but I don't think they have murder here. I don't think they can prove that beyond a reasonable doubt, and that's the problem with their case.
In my opinion, perfectly said. Andell Brown, let's pick up where we left off in our review of the closing argument. This is the rebuttal from the prosecution. Okay, we're taking a look back at the rebuttal closing arguments from prosecutors in the Tex McIver murder case out of Atlanta, Georgia. The jury got the case yesterday. They still have the case. No verdict. Jury took lunch a little bit, about an hour ago, I should say. But this is one of these more interesting accusations in this case. Charles Mittelstadt, you're from Atlanta. What do you make of this insinuation, this accusation that Tex McIver is just a gigolo? He's out there looking for somebody to basically fund his high-flinging lifestyle. Diane McIver was it. That's the sort of stuff apparently we see in movies, and the prosecutor went there.
Well, speaking of movies, I mean, if in fact that's what was going on, then he ought to be an Academy Award winner, just based upon the testimony that we heard, not from defense witnesses, from the state's own witnesses. There's nobody that came in there, even during the state's case in chief, that relate anything other than the fact that these two individuals always displayed nothing but a caring, loving relationship towards one another. Everybody agrees on that. Nobody has talked about any sort of acrimony whatsoever. And so this notion that Clint is trying to sell, that somehow, what you saw it was different behind the scenes, and in reality behind the scenes was this was all a facade, and there was no real love, and Tex is a kept man. That's complete nonsense. And it's nonsense because, again, we know through the state's own witnesses, these are friends of Diane's, friends that she loaned money to, that she charged the same interest rate, people that she loved just like she loved Tex. That's just the way she was. She was a very shrewd businesswoman, and when it came to money, she was incredibly serious and disciplined about that. Now, we also don't know what all the tax implications, some of the justifications, some of the logic behind the structure of some of this between a husband and a wife. I suspect it has a lot to do with taxes, and it has a lot to do with protecting their own loved ones in the event of their death, to ensure that the proper distributions happen based upon any debt that may exist. So this is, again, it's a great tale, and Clint Rucker is very forceful at telling it, but at the end of the day, it simply is detached from certain realities and from other evidence in the case.
I agree with that assessment, but look, one thing I was waiting for in this case that I didn't see is exactly what you suggested. I was wondering if this loan back and forth between the two was not necessarily Diane McIver being proprietary and guarded about her money, but rather that it was some kind of a tax avoidance situation or some kind of an estate plan. If you mortgage money to somebody else, and they keep separate finances, well, mortgage interest is deductible. Was that something that was going on here? Were they using that to offset their income by deducting a mortgage that he took out from her? Is that possible? I didn't hear a clear answer in this case. Andell, what do you think? I mean, I know that you're probably not into tax law, but is that at least colorable?
My head is spinning, Aaron. But to make a long story short, what I saw there and what I heard from the prosecution, it didn't seem to make their case. Because even if you want to state, as the prosecution was insinuating, that Tex McIver is some type of American gigolo, a Richard Gere impersonator, that he absolutely picked the wrong person. Everyone that deals with Diane McIver says she's a shrewd businesswoman, she's about her money, and she watches her pennies. Now, if you're going to get money from her, you're going to pay it back. He got some money from her, but he had to give up his property and other things like that. So obviously this wasn't a relationship where she's just doting on Tex McIver and spending money on him with no repercussions. Every dollar had to be accounted for. That's not a gigolo situation. That's a situation between a husband and wife where the finances are watched closely. They're making strategic decisions. And I think it does go back to the point that you have made, Aaron, as well as Charles, that this could have been some type of estate planning issue or tax planning issue. I absolutely don't think it had anything to do with being an American gigolo.
That's what I would think, but I don't know if it was developed as well as it could have been for the defendant's benefit in this case. Surely somebody could have gotten in there, but I don't know, maybe they figured, hey, look, there are way too many accountants on the stand, way too many legal professionals. I mean, I feel like I took wills, trusts, and estates all over again by watching this case. You know, hand a law degree to the members of the jury at this point. You know, they've pretty much heard it all. Right. I want to continue our review of testimony. Let's pick up with Clint Rucker, the senior prosecutor in this case, where we left off. Okay, we've got a lot to break apart right there. We're back to the whole issue of whether Tex McIver is a gigolo. They've got this email that says, oh, I'm gigoloing, so the prosecution wants jurors to take this seriously. Andell, do they take it seriously, or do they know that this is a joke?
I think the jurors are not going to take that seriously. From the questions we've seen from the jurors, they're really focused on the main issues in this case. They're not really getting distracted by these side issues that keep coming up. And I think it does a disservice to the prosecution to have jurors spending time on these issues. Their credibility is going down each time they take a shot in the dark. And they would be much better served if they just focus on the strong points in their case. I think this case, if it were in a civil court and there was some type of wrongful death, you absolutely get a judgment in favor of Diane McIver's estate. But I just don't think you're going to get a murder charge beyond a reasonable doubt here in criminal court.
Yeah, I mean, if financially he owed her estate money, well, then sure, that should be paid out in some fashion. Totally different burden of proof, totally different standard. You look at the evidence differently. In civil court, this is beyond a reasonable doubt. This is criminal court. Maybe this is an issue of characterization. I'm wondering if that's the issue here. You know, does the prosecution, Andell, use this as something to characterize but not go at the argument full throttle the way that Clint Rucker does here in this rebuttal? Do they bring it up and say, hey, look at this email. Something about this just might tell us something about the mind of Tex McIver. And just drop it like that, to not go into it and just say, that's what he is. He's admitting his true nature. The difference might be in the characterization.
I think it would be a much wiser strategy for them to stick to the fact that Tex McIver is not acting the way a loving husband would under these circumstances. His communications and other things like that are not consistent with the image he's trying to portray. I think the best thing that the prosecution could bring out is that Tex McIver is projecting one image to the world, but he's a whole different person. If they can stick with that theme, I think it serves them. If they're trying to put things on him like, oh, he's a gigolo, and this one line in an email proves that, I think their argument loses steam.
I agree. I think it's a question of just how far you take the argument. Now, Charles, they're also back in that last clip to this whole issue of whether there is a new will. And look, the prosecution wants everybody to believe that there is indeed a new will, but I think the defense has got this part of the argument correct, and the prosecution is reaching so far, it's not even funny, because look, if there is a possibility that there is a new will, as the defense pointed out, it's published in a legal journal. All the attorneys in the Atlanta area read this journal. They get it. You probably got it. There's a notice in there. If anybody out there helped Diane McIver with a secret new will. Now is your chance to come forward. They are probating this estate. You better cough it up now. No one has suggested that there is a copy of this new will. No attorney has come forward. Nobody else has come forward. The only thing they've got is an assistant who thought that she might have had a copy of it but wasn't sure. That doesn't sound like evidence that there was a new will, but Clint Rucker is pretty strong in wanting that jury to believe that there is one. Charles, what do you think?
Again, it's pretty consistent with other evidence that simply hasn't materialized in this case. It just is not preventing them from making the argument, which is somewhat baffling at times. I mean, you may see that in a case maybe once or twice, but there's example after example of occasion where they've taken less than developed evidence or non-existent evidence, and they've argued it to the jury as if it's fact. And you're correct. In this particular case, they literally left no stone unturned in terms of trying to identify this supposed other will that exists. And they did publish it, and there's over 18,000 attorneys in Metro Atlanta that would have received that notice and that would have been able to respond to it. They executed search warrants. They interviewed everybody they possibly could. It turned out to be a dry hole. But somehow, mysteriously, they continue to argue this notion that there has to be another will out there. And so I really think that ultimately is detrimental to their argument. And then also when we talk about this, these appearances, it also tends to run contrary to a lot of their arguments because there's other behavior on Tex's part that is completely inconsistent with someone who would have premeditated this and thought it through and would have had a lot of concern and taken much care as to the appearances of his own conduct. And yet some of his conduct is baffling and runs completely contrary to someone who would have planned this out and premeditated it. So it's almost, he was damned if he did and damned if he didn't, and they want to have it both ways.
That's what it seems, yes. Okay, so let's pick up our review of these rebuttal closing arguments with Prosecutor Clint Rucker where we left off. Okay, Clint Rucker brought up a couple of facts in that clip that are things that just make the defense squirm a little bit. What do we make of this whole comment about Tex McIver apparently loving red wine, but it gives him a headache? Is it a discrepancy, or is this like a friend of mine who has a gluten sensitivity, but who still sometimes will eat cookies because she loves the way they taste and then suffers the consequences later? I mean, is that one way to interpret this, or is this evidence that the guy is lying to the police? I'll throw it on the table. Charles, what do you think?
It could potentially be a less than forthcoming statement on his part. If I recall, it seems like Tex and Diane had a pretty substantial wine collection. So my impression was always that, they imbibed fairly frequently. So whether he's just trying to diminish and he's concerned about his blood alcohol level contributing to the potential reckless conduct case that could be made against him at that time before any charges were lodged, I don't know, but it seems like something that's less than genuine to me. Now, whether he had, as you mentioned, some sort of adverse reaction to it that he was willing to tolerate because his love for wine exceeded the discomfort that he experienced, who knows?
Yeah, it's just another one of those bizarre things. Now, the stickier situation, Andell, is this situation about the ranch hand being asked by Tex McIver to bring Danny Jo Carter home. As Clint Rucker pointed out, that if that had rolled forward, it would have meant Tex and Diane were going to be by themselves. Is he meaning the defendant, trying to isolate her, to do something to her, or is this just that they wanted to have a private dinner without the friend there? How do we characterize that?
The tough thing, Aaron, is that the prosecution expects us to answer this question without providing the answer. When it comes down to a case with the prosecution, I always tell my juries, it's www.askthestate.com. They have the burden, they have the obligation to answer these questions. If they can't answer the question, then it's automatically not guilty. It's not for us to speculate about what that means. We don't know what that meant. but the state hasn't provided a good answer, and that's to the detriment of their case and the conviction that they're seeking.
You know, don't say that phrase too much, Andell, because you might get quoted by somebody. Somebody else now is going to say, if you don't know the answer, members of the jury, you got to go to askthestate.com. It's on them. I think that people might pick up on that from you, so you might want to guard that a little bit more closely.
I'd have to do that. I'm gonna tuck that in my pocket here.
Okay, well, don't let it loose like mixing up a jar of water. We've already discussed that issue. We've seen that in this case.
That one's taken.
Yeah, again, let's. That one's taken by the man. We're going to continue watching here. Here's the prosecution on rebuttal. Okay, guys, look, here I will admit the prosecutor makes some pretty good points about trajectory, how the gun was being held. But look, I think that this argument sounds a lot more like criminal negligence than it does murder. Saying that he shouldn't have been holding the gun in that position sounds like a criminal negligence argument. Andell, do you agree?
I agree there can be an argument made for criminal negligence. I think someone of Tex McIver's experience with guns, based on the testimony we've heard, should know better than to have your finger on the trigger of a gun with no threat in sight while sleeping or whatever he claims he was doing. And the fact that, you know, his story changed according to the witnesses about whether there was a bump in the road, about whether, you know, it was homeless people or Black Lives Matter or whatever it was at that point in time, I think indicates that he does not have a good reason for why he would have had the gun in that position at that time with the level of experience he has in handling guns.
A lot of people, Charles, are saying that the reason that he had the gun wrapped up in the plastic shopping bag was to prevent the gunshot residue from flashing out towards the seat, and therefore he was preventing the police from knowing exactly how close to the seat the barrel of the gun just happened to be. Do you buy that argument? It's
an absurd argument. In fact, 70% of what Clint Rucker just argued is not in evidence. It's not the evidence that came out of their own state's witnesses or the defense expert. He was handling the gun. He said it was being held by the handle and it was being pointed in a certain way and it was held on the side. None of that was proven in this case. Not one shred of that came out in this case. And as to the plastic bag, it would have been in if Tex had premeditated this. And had fired it from his lap, it would be to his benefit for the gunshot residue to be dispersed so that it would be obvious where the gun was laying if it was laying on his lap. The notion that it would have been held to the side has been demonstrably false, just based upon the measurements, based upon the trajectory rod. They had the in Clint's clothes yesterday, he was showing where the expert sat in the car and had his finger pointed at trajectory level. And that's it's inconceivable. It's inconsistent with the evidence, because that would suggest that the trigger is at the same level as the barrel. As Bruce Harvey pointed out, it's 2 to 2.5 inches higher. So that's not even conceivable. And there's still an argument that the jury is going to have to sort out as to whether it's even possible physically, based upon spatial limitations, to even have the gun by the side. I suggest it's probably not. So the plastic bag would not have benefited him at all. And also, I think it's important to dispel this notion that somehow his finger had to be inside the trigger guard. That in the double action mode, the trigger was 12 pounds. In the single action mode, it was 2 1/4. 2 1/4 is so light that if you just brush up against the side of that trigger, you don't need your finger in the trigger guard, just brush up against the side of it. It is sufficient to discharge that. The best thing that could have possibly happened, you couldn't have asked for a better moment as a defense team, is when the state's own expert accidentally discharges it. It just shows you how easy it is to do on that gun. And the jury is going to have that gun. They have the gun back there with them. I'm sure at this point they have all tried to fire it in that single action mode. And they have, I'm sure, satisfied themselves with the fact that it is entirely possible that just by brushing the outside of the trigger is sufficient to discharge that weapon. So, I think there's a very plausible explanation for how that could have accidentally discharged. The problem, again, is how a responsible gun owner The question is whether it is reckless for a responsible gun owner to have a loaded, cocked gun in the back seat while he has been imbibing. And the answer is probably no, that's not reasonable. It's certainly not good gun safety. And I think that's why he is exposed to the reckless conduct charge.
Yeah, I mean, now we're back in the area of the lesser includeds yet again. So final question for the both of you. Andell, I'll start with you. We have a Twitter poll up. It's in its last hour here. This is a 24-hour poll asking people what they think if they were on the jury. And right now it's holding at about 27% of our viewers who are on Twitter have said they think Tex McIver is guilty. The majority think that he is not guilty, 39%. 34% think this is an involuntary manslaughter situation. That's one of the lesser included charges. Andell, that indicates a split, that there are some people who think he's guilty. Many do not. Are we setting up this case after all this time for a hung jury?
I don't think we're going to have a hung jury, Aaron. I think that more than likely, if the juror's going to make some type of concession, I think it'll probably be going for the lesser included, or what they call splitting the baby. I don't think they're going with the murder charge. I don't think the state or the prosecution has established that charge. But I think most people feel when they look at this case, when they look at the evidence, that Tex McIver, he's probably not guilty of murder, but there's probably something else going on there. And a lot of times the way juries deal with that type of emotion or that feeling is that, okay, he's not guilty of the big charge, but we think he's guilty of something, so we're going to give him one of the lesser charges. I think this is one of those cases that is ripe for the jurors splitting the baby, and I think the poll that was taken kind of shows that with these various splits, that they're probably going to come up with something, and I think it's going to be the lesser included for the negligent homicide.
Charles Mittelstadt, what do you think?
I couldn't agree more. I think exactly the same sentiments. I think in the process of trying to make this murder case, they actually made a very compelling involuntary manslaughter, reckless conduct case against him. It's the way the case was originally charged. It really is what this thing is all about. And I think at the end of the day, that is the concern for the defense, is that is likely the verdict that the jury will come back with is a guilty on manslaughter and involuntary manslaughter and reckless conduct.
That's my opinion as well. Look, I've got a piece up on lawandcrime.com. You can take a look at it. I spent a lot of time thinking about it. I link to the statutes and walk people through the analysis. I always fear that jurors will sort of say, well, it's not the top charge, but we think he did something wrong. And they do, Andell, what you described as this sort of splitting the baby, because that's not necessarily following the law. But I think that if you read the letter of the law, and I invite everyone to do it always here, this is the Law&Crime Network, take a look at the piece I have up, because I break that all down. So we're going to switch gears a little bit here. Andell Brown, Miami, Florida, Charles Mittelstadt, Atlanta, Georgia. Appreciate you both joining us here over the lunch break on the Law&Crime Network today.
Thank you.
My pleasure.
All right, we're going to switch back to take one last look at some of the prosecution rebuttal arguments in the Tex McIver case. When we come back from that, we're preparing to bring you to initial appearances in Brevard County, Florida. So first, more of those rebuttal arguments.